I can only say that one of my most wonderful memories when I worked at the Department of Justice as a standing agent was when now Justice Gorman, then Kelly, invited me to speak and assist in a program that she was running to help improve the integrity of the drug prosecutions and assist the police officers to understand what their role was as experts when they would testify. And I participated a couple of years in a row in that program, and it was a wonderful experience that sort of was part of one of the reasons why I like being involved in teaching and trying to teach. Anyways, let me turn it over to Nick. And if you can do the introductions and run, there is a handout. I just looked on the website, it's not yet posted. I apologize. We try to do everything out of the back of our garage, and we'll try to get up there as quickly as possible. But if anyone in the room wants a thumbnail sketch of the proceeds of crime and offense-related property handout that they have, I'll be passing them around. Multitasking.
Thank you, everyone. Thank you for staying in the heat. We appreciate your forbearance. We'll try to keep this short. We know it's a school night and it's getting warm and your brains are full. And really, that's why we've chosen the single most interesting topic in criminal law, which is offense-related property, or as many of you might know it, the retainer.
They get worse.
I'm Nick Devlin. I run the appeals unit for the Federal Crown. That makes people think I know stuff about the law. That's why I'm here. Kelly's here because she's smart and beautiful and a judge. And Mike's here because he actually knows something about proceeds because he actually runs our IPOC unit in London.
And I'm the opposite of Kelly.
Well, and I'm wearing a ponytail now because I thought I was having a major hot flash, which I may or may not be having. But I'm glad to hear some of you also are having it with me. So we'll try and keep this short, I'm sure.
Our first question, and we're going to try and keep this really basic because this is an area not a lot of people end up having to deal with, is what proceeds of crime. I think we know what those are, but what are proceeds and offense-related property in really simple terms?
Okay, well, proceeds of crime is a definition that is governed by the Criminal Code of Canada, whereas offense-related property is governed by the Controlled Drugs and Substances Act. So those are the two terms and the two pieces of legislation. Proceeds of crime is defined as any property, benefit, or advantage inside or outside of Canada obtained or derived directly or indirectly as a result of A, the commission in Canada of a designated offense, or an act or omission anywhere that, if it had occurred in Canada, would have constituted a designated offense. And for this purpose, that is proceeds of crime, criminal code, designated offense means any offense that may be prosecuted by way of indictment under the criminal code or any other act of Parliament, or a conspiracy or attempt to commit, or being an accessory after the fact in relation to or counseling to commit any of the aforementioned offenses.
So the crime doesn't have to have happened in Canada, is that right?
That's right.
And you do not have to proceed by indictment, it merely has to be hybrid.
Exactly. As long as the Crown may prosecute by way of indictment, that makes the offense an eligible one for proceeds of crime.
Crown can forfeit police buy money if they find one of your clients with crack, simple possession crack. That's a hybrid offense, right? Schedule 1. If there's a conviction for a 4-1, even if they're charged with 5-2, Crown can move to forfeit the buy money or whatever money else is found on your client.
We need that 20 back. It's been a lean year.
So that's proceeds of crime. For drug-related matters, for offense-related property, the Crown needs a conviction for something called a designated substance offense. and that's defined basically as anything that's not a 4-1. A 5-1, a 5-2, a 7-1, importing, those are designated substance offenses.
And under the criminal code, what is covered by ORP?
ORP under the criminal code. Now this would be more like your drunk drivers. Presumably police or Crown might want to take a car away from a repeat drunk driver or a repeat drive while disqualified. If that accused is charged with an indictable offense, dangerous driving, impaired, drive while disqualified, but if the Crown goes by indictment, then that car can be seized and is subject to forfeiture under the criminal code, offense-related property.
So for offense-related property, does it have to be actually prosecuted by indictment?
Yes.
And there needs to be an offense proof?
Yes. All of these are all of these are conviction-based, what we're talking to you about tonight. We're not the civil remedies guys from the province who sue your money because it's bad, or sue your grow house because it's bad or unlawful. These are all forfeiture applications based upon convictions or in some cases discharges, but there's been a finding of guilt.
Okay, so when are these issues dealt with before the court?
Okay, well, this is, in both instances, in terms of proceeds of crime, so that's under the criminal code, this is when, it's dealt with when an offender is convicted or discharged of a designated offense, always on application by the Attorney General. Okay, that's proceeds. Offense-related property, that's Controlled Drugs and Substances Act. When a person is convicted of a designated offense, again, on application by the Attorney General.
Sometimes our Crowns forget to ask for forfeiture. And then about 3 months later, police or someone in Ottawa calls up and says, what am I going to do with this car? What am I going to do with this bag of money? What am I going to do with this grow equipment?
Plane.
What am I, plane?
You resell it to them? Oh.
No, we give it back, and it makes me angry. But because I have to do the damn paperwork.
Truth, we actually prosecuted a case once where there were not one, not two, but 3 separate seized Property Management Bureau inventory number stickers on the grow lights. They buy them back. Okay, so who else needs 800 high-power grow lights?
Not to belabor things on a hot night, but we can also go after property even if you're dead. So we don't necessarily need a conviction or a discharge then, but the burden of proof increases. We think about it sometimes. We've had cases where my colleagues and I were about to restrain a house or something like that, and then we find out the accused is dead. And we give, actually I have forfeited property after the accused died. He pleaded in March in Hamilton, March of 2010, and he had a co-accused. But he went over for sentencing in a forfeiture application. And in the interim, he died. And, but we had kind of progressed to the point where I wanted to continue with the forfeiture application anyway. I just had to change the section numbers. And under the CDSA, it was in section 16.
Let it go.
Well, that's the only...
Now we know who bears the moral burden, but who bears the persuasive burden and to what standard?
Okay, well, in the typical case, and I'll talk grow houses now, I'll talk CDSA offense-related property. This is tools of the trade. This is property that's used to commit an offense, and there's a conviction or a discharge for a designated substance offense, which again is anything other than a 4-1 under the CDSA. Typically, the burden on the Crown is this. So we need a conviction or a discharge, and then we have to prove on a balance of probabilities, typically, that the property is related to the conviction. So if someone is convicted of production of marijuana in their house, I would imagine the Crown can convince a judge on a balance of probabilities that that property, the house, is related to the offense of production. The production took place in that house.
How related does it have to be, though? Because I dealt with a case where the fellow was manufacturing MDMA or MDA, huge quantities, but he wasn't doing it in the house. He just stored it in the house, sold it from the house, and kept his records in the house.
Yeah. We have to prove on a balance of probabilities that the property is offense-related property, and that offense-related property is a very broad definition. The Supreme Court calls it broad in the Craig case. Did you read the definition, Justice Gorman? It's a very broad definition, you know, used in any manner in relation to the commission of a designated substance offense, intended for use for the commission of a designated substance offense. And I forget what A says, but
by means of which a designated substance offense is committed. So one might assume that you could only have production in a house if the house is the structure which contains the marijuana.
Right. Typically, in most of the reported cases, defense counsel concede that we can make this huge hurdle.
The question, Kelly, when is forfeiture automatic and when is it discretionary?
Well, I'll leave automatic to Mike, but discretionary, there are a lot of what I call judicial loopholes in the legislation and in both sets of legislation. Now, firstly, under the criminal code, there is there's this section that says, well, firstly, I mean, forfeiture shall be made if the Crown has satisfied the court on the balance of probabilities. Okay. And here's escape hatch number 1. A court shall not make an order of forfeiture in respect of any property that the offender establishes. So reverse the onus on a balance of probabilities is not the proceeds of crime. So that's the first little switch there. And
Yeah.
Jeff, what do you say to that?
Well, that's under the proceeds of crime legislation. The main hurdles, I'll tell you, as a Crown that we face is we face a lot of, when we try to forfeit cars, a lot that have been used either to move dope, or someone's dealing 40 pieces out of the side, out of the window, or driving downtown and meeting an undercover cop to do a deal. A lot of times we find that those cars are registered to other persons' names other than the accused. So all of the forfeiture regimes are all kind of set up the same way. You know, the judge shall order forfeiture subject to, you know, the rest of the legislation there. And the legislation always insulates or protects or gives protections to third parties, to persons who claim to be valid owners. And I don't use that word loosely. I think that's actually how it's, you know, a person who claims to have a valid interest in the property, you know, has an ability and shall be heard by the judge on a forfeiture application. So,
Give us an example.
police
Stop someone in their car. There's a whack of dope. Seize the car, looking to forfeit the car.
Depends who the car is registered to. Now, what we find is registered owners doesn't necessarily equate with lawful owners. But and you probably don't know this, but usually when police seize a car in Ontario, outside Ottawa, it usually goes through me. So
You should see his driveway.
yeah, but there's kind of a preliminary examination of the case for forfeiture, even at, you know, within a few days of the seizure of the vehicle by police. Oftentimes, especially in the case of vehicles registered to other people, I will ask the police, well, what connection do we have between, like, how do we prove that the registered owner isn't the lawful owner? do we know who bought the vehicle? And we have a, well, let me look around. Okay, I don't know many of you. There may be a case in Oshawa where a car was forfeited in March, and it was registered to the mother of the accused. Now, the mother of the accused is bringing an application to set aside that forfeiture order. She is saying, hey, I'm the registered owner of that car. That's my car. I wasn't involved in any of these drug dealing offenses that my son was convicted of, and I didn't know he was a drug dealer, and all these sorts of things. What we do typically is we try to check out to see who actually purchased the car, who's paying for that car. Police can do this if they could get off their butts and do it. So in this instance, police went down to the car lot in Hamilton where the car was purchased, and lo and behold, it wasn't Mom who bought the car, but they put it in Mom's name. So that's something. We also check out to see who pays for the car, like I said. But getting back to the initial seizure point, sometimes police will call up the registered owner of the vehicle and they'll say, hey, Mom, we just caught your son with like 40 pounds of pot in the back of the car registered to you, that 1986 Camaro. And we see that you're 70 years old. What's up with the car, Mom? And oftentimes, but not always, but oftentimes, the registered owner will say to police, it's not actually my car. It's in my name for insurance reasons. Or he put it in my name. That happens a lot with girlfriends or spouses. Or he couldn't get insurance, so it's in my name. So
I think this typically happens more in the Ontario court than it does in the Superior Court, Mike. But
Yeah.
I mean, I would think there is going to be a full hearing on this.
right. We, and oftentimes I think if, at least my experience has been, if you as defense counsel can present, you know, some information or evidence to the Crown you're dealing with that the vehicle is in fact Mom's or is in fact sister's or is in fact Dad's, oftentimes the Crown may throw in the towel, for lack of a better word, because we don't really want to store vehicles that we can't forfeit. That's the bottom line. You know, and that's why usually when the vehicles are seized at the beginning, there's a little bit of an analysis on what do we know about the registered owner. Does that registered owner appear to be the lawful owner? We don't want to store vehicles and incur the costs. And
I think the story's got to be a lot better than, I don't know if this is still the go-to explanation, but
It's the rent.
when
Right.
one was stopped in the course of some sort of investigation and found with $40,000 in an envelope under the front seat of the car. That's interesting. You know, what's that all about? Oh, I'm just on my way to buy a car. Like that was the go-to explanation that I always heard. And I mean, maybe people do that. I don't know.
yeah.
But I think it's got to be a little bit more than that.
How familiar would you say most courts are, though, with proceeds and ORP issues?
We were just talking about this because I have an office next to one of my colleagues in the Superior Court in London, and last week he came in and he sat down. He said, "Hey, so I'm doing a case. It's a proceeds of crime forfeiture case. Federal Crown is involved in it." Oh, that's interesting. He goes, so is this some like new law? Well, new-ish, I guess. So, yeah, so, I mean, know your audience, right? I mean, just think amongst yourselves, in the members of us here tonight who are on the defense side, how many applications of this nature have you done? Well, chances are you're going to be met with a similar sort of audience on the judicial side. So.
Now, one thing that comes up a lot is because obviously losing a car or a house is a big deal compared to the extremely punitive and denunciative 8-month conditional sentence that he's about to receive, which clearly serves the purposes of deterrence and denunciation as opposed to losing his $150,000 in equity. How does this factor into discussions about resolution? Because I mean, my experience, it's often been a stumbling block in many cases. They'll happily take the sentence, but guess what? They want to take someone's house. That sort of changes the conversation a lot of the time, or the car.
Right.
How do these? The Supreme Court has said it's not punishment, strictly speaking.
Right.
But how does it practically function into the resolution discussions?
Well, the Supreme Court in the case of Craig said that offense-related property, now we're dealing with offense-related property under the CDSA. Craig is the first case on your list of cases you should know under offense-related property.
The Supreme Court split, the 7 members split very helpfully, 4-3-3-2-2-1-7 or something like that across the 5 issues. It's extremely clear. Counsel in our office who argued it says he should be able to tell us what it means within the year, I think. So you think I'm joking? It actually
Craig told us a few things in a split decision on a few on the major issues. But the main thing that, well, there's 2 things that come out of Craig. The first thing is the court said in its majority of 5 or 4 that you can't horse trade sentences and property, basically. You can't, a Crown can't say to defense counsel, look, your guy deserves 2 years, but if we forfeit his house, I'll agree to a 10-month conditional sentence. Justice Abella for the majority said that basically allows persons of means, persons with property, to buy their way out of jail, is what she was concerned about. The other thing about Craig, just so you know, is it said the partial forfeiture is possible. And what is partial forfeiture, you may ask? Well, there was a thinking in Ottawa that forfeiture was an all or nothing bargain, or all or nothing, what's the word I'm looking for, scenario, situation. It was either you forfeit a house or you don't. That wasn't actually the practice, but the Supreme Court said, and this is in terms of real property, you can forfeit some, all, or a part of real property. So the court called that partial forfeiture. They said that is a reality. They said that in Craig, and they said that in a case from Quebec called Willette, which is also listed in your handout. Willette, what happened, and there's also a case in Ontario Court of Appeal from 2009 called Baldacero. I don't know if you want me to talk about Baldacero briefly, but no, okay. Well, I can do it in 13 seconds. Okay. Baldacero, Church of the University, heard of these fellas? They ran a place in Hamilton where they may have been selling to undercover officers and other people, small amounts of hash and pot. It's
called Sacrament.
Sacrament. And it sounded like their church was on the ground floor of a building, and they lived in the apartments above the church. Well, after a trial in the Hamilton Superior Court, the judge there ordered full forfeiture of what he called a church disguised. No, it was a Prohibition era speakeasy disguised as a church. Basically it was a building set up to sell marijuana. He ordered forfeiture of the entire property, the entire building. Well, at the Court of Appeal level, the court thought, they looked at the property and they said, well, you know what, that top floor of that building, it wasn't being used to sell drugs. It wasn't really being used for anything illegal. They were just living there. But the bottom half, That's where all the bad things were happening. So the Ontario Court of Appeal replaced the full forfeiture order with partial forfeiture, sorry, it's hard to get out sometimes, of 50% of the equity of the property. So thank goodness what had happened was the bank who held the mortgage on that property had commenced power of sale proceedings, and I think had sold the property at the time, and there was like $22,000 left over. So I think the government got 11, and 11 went back to the good reverends, the brothers.
Now this is
that's partial forfeiture.
This scheme is the subject of a lot of clear thinking and very clear legislative drafting, and it's very complicated. So if you ever actually have to do a case in this area, you just really have to go back and reread everything slowly, not at 9:30 at night, because every time I get a question on these issues in the process, I have to go back and read the relevant sections. Things are different between the criminal code and the CDSA. Under the CDSA, only houses have a proportionality analysis. Okay, everything else it either is or it isn't or. Right. Under the criminal code, everything is subject to a proportionality analysis. So the question basically is just a very broad factual question. Is it unfair? Is it disproportionate? Another way of saying, I guess, unfair or unreasonable to take the whole thing? Right? With houses are a very special case, and houses tend to be forfeited under the CDSA, not so much under the criminal code. I'm not sure I would use maybe a body house or something like that, although it
chop
may seem
shops,
illegal. Right.
Real property chop shops. They were talking of doing one in Kitchener a few years ago, where a guy was manufacturing child porn in his house. The police were talking about restraining his house. I don't think they ever did, but that would be a case where criminal code charges relate to the real property.
But functionally, it's in drug cases, and there the court is charged with considering the impact on the people who live there. The Crown has to serve the people who live there. I suggest to give you 5 seconds of the ethical content. As defense counsel, you probably should assist the people who might have an interest in making sure they get notified about these hearings and are represented. And then the court has to kind of ask that difficult question: do I throw the wife and the children out of the house because daddy was a drug dealer or not? And that's why we get a lot of this sort of Solomonic sawing in half goes on. The better off drug dealers write you a check for their half.
Yeah. And there's
the
always
less well-off ones move to trailer.
Right, but there's always going to be, if it's a matrimonial home, there's always going to be a family law component too there. So, I mean, that's an issue to be considered often in grow houses. It's just some random house. Nobody actually lives there. It's, easily forfeited.
I wouldn't consider it wrong or unprincipled in any way if you're trying to resolve one of these cases, to make a proposal, if your client will instruct you to do that someone will plead to the offense that's going to get proven anyway, and propose some sort of proportionate forfeiture that if your client wants to keep the house, it doesn't want to run the risk of a cranky judge taking all of it, because that has happened on quite a number of occasions. This is one where the Court of Appeal has given back a little from the front line, has been relatively merciless on this front. I don't think it's unprincipled to make a proposal, say he's got this much equity, we'll come up with this much money as a fine in lieu. So that might be a way to consider.
Oh, absolutely. So, Biff, sorry, Mike. Yes. I call him Biff. For our defense practitioners, is there a way to satisfy forfeiture and yet get paid? How does one do that?
Sorry, what's
make that happen?
What?
There are assets to be forfeited, but
right.
Can it be crafted such that part of the forfeiture can be somehow
returned to defense counsel? Okay, that's frowned upon. I know it's happened. I know I've done it. It's probably easier with proceeds of crime, to be honest, because There's no disproportionality considerations in proceeds of crime. Like proceeds of crime, think of it, there's a bag of money.
So proceeds of crime under the criminal code,
Yes,
remember?
yes. Your client is charged with possession charges for drugs found in his or her house, and a bag of money is found in a safe. Police scoop the money, call it proceeds of crime. Then the Crown has to prove it. That's sometimes tough. So, I know that on occasion, you know, realizing this burden upon the Crown, we've, you know, gotten reasonable. We've said, okay, well, maybe we could have proved that some or all of this was proceeds of crime. Maybe we couldn't. Why don't we saw it off? I've done that before, and I'm suggesting to you that probably some other Crowns that you may deal with will do the same.
Applications can be brought to Superior Court for legal fees to be paid from the proceeds. The extent to which that can be done is still a little bit of an open question, but we do have a couple of ongoing orders of that nature. Just be warned, depending on the province and the Crown, there may be a case where if it's proven to all be proceeds, the Crown could, in theory, ask for a fine in lieu for the amount that's been paid to the lawyer against the client, not the lawyer.
The fine in lieu is a concept where after a trial or after a forfeiture hearing, a judge says, okay, that $100,000 that was in the accused safe, I find that is all proceeds of crime. I want to forfeit it. I shall forfeit it. That's what the criminal code says. Uh-oh, I can't forfeit it because $60,000 of it was returned to legal counsel for reasonable legal fees. If money has been dispersed or otherwise made away with, but that money was found to be proceeds of crime after the trial, the Crown can ask that the judge order a fine in lieu be assessed against the accused. And what's that? Well, a fine in the amount of the disappeared proceeds. In this case, my hypothetical example, $60,000. So if you get reasonable legal fees paid out to the tune of $60,000 and that money is eventually found to be proceeds of crime after a trial, the judge can assess that against your client as fine in lieu. Now, the real interesting thing about fine in lieu is not only a fine is assessed against your client, but and your client will be given time to pay at the discretion of the judge. If your client doesn't pay that within the time allotted, there are some mandatory minimum sentences in the criminal code, and they're pretty rough. They're pretty tough.
Up to 5 years, right?
Yes.
Yeah. I'll finish on this point. The Supreme Court in about 13 hours will be releasing the first and kind of hopefully authoritative judgment on the test on ability to pay, and the fine in lieu applies in this case called TOP that Andras and I argued in March. Unfortunately, they couldn't get him to give it to us today. It's probably going to be worth reading. Very simply, a fine in lieu can be ordered anytime it's been proven that proceeds have passed through someone's hand. If you've handled proceeds, even briefly, not taken a profit from them, they've just passed through you, you are liable dollar for dollar for a fine for that amount. And so clients could be convicted on that basis. We can prove that they did $1 million worth of drug deals over a few years, but the money's long gone. When money has been mixed with other assets, which are partly legitimate, part not, it's offshore and can't be found, which is the case in TOP. In all of those instances, fines in lieu can be imposed. Unlike criminal code fines, there's no ability to pay analysis. The fine is automatic. However, the collection provisions of the code, they merge back once you try and go and get the money. Right? So a normal fine, there has to be an analysis of ability to pay. What that really means, how that should be done, we will know tomorrow about 9:45. Under fine in lieu, it's just imposed. When you try to collect if the person hasn't paid, it still has to be determined that it's a willful non-payment. So someone who doesn't actually have the money will not be sent to jail, fine in lieu or otherwise.
I should add that although I tried to scare you with the money being paid out to reasonable legal fees and the Crown can ask for fine in lieu, there's competing, conflicting even appellate court decisions on that. There's a decision, I believe, from Manitoba, and now the name escapes me. But in that case, the court said, yeah, the Manitoba Court of Appeals said money paid to counsel for reasonable legal fees that was declared subsequently to be proceeds of crime, you can do a fine in lieu on that. The Newfoundland Court of Appeal in a case called Appleby or Connolly, Appleby said, no, that ain't right. That's a judicial order, ordering money to be paid to counsel for reasonable legal fees. That should be excluded from the consideration of dispersed or hidden or.
So judges can launder money.
According to the Newfoundland Court of Appeal. And as far.
But that might be interesting. Just sorry to stop you, Mike, but I mean, if you're going to have that chat with your client about, I'm going to make an application to the court to release what might down the road be found to be proceeds of crime, you'd best sign this waiver. So I'm going to get paid, but listen, 2 years from now, that may be found to be proceeds of crime, and you may be looking at either repaying that amount or doing a little bit of time in lieu of that forfeiture. So I'm just thinking that might be something that you want to think ahead of in terms of getting instructions.
No, that's probably very solid advice. I wish I had I wish I had brought those sites for you. The two cases.
I think they're mostly good. And to wrap it up, let's just do it. To wrap it up, the one thing I want to say from an appeals standpoint, in these sections, there is a very odd system of appeals and reviews. If somebody comes in and said they took my son's car, it's really my car. Can I just encourage you, the first thing to do, call the Crown and express the intention to appeal. I've granted extensions to people on several occasions now, just because they've gotten lost. They filed an appeal to the wrong court for the wrong thing. These sections are a mess. I'm just warning you. We're not going to straighten them out. If they come across your desk, red light, read them carefully, tell the Crown right away, express that intention to appeal.
Sorry if that was dead boring.
Thanks, guys.
I just want to thank everybody, but prior to that, there was the one question about trying to have funds released to assist in
Always thinking
paying
about
for
you,
the
Paul.
cottage. In any event, you have to recognize the fact that there could be a severe penalty for your client. And it's not only a waiver, but it might be a requirement on defense counsels to send your client out for independent legal advice. Because they're going to have to understand that depending on how the prosecution is completed or whether there is a conviction or not, they can face going to jail. And it can be seen as something that is enhanced above and beyond what they could expect from your initial review of the case and the expectation level that you developed for them. And so in order to ensure that they have proper understanding of the ramifications, they definitely need independent legal advice. Are there any questions in the audience? Or if there are any questions, we'd love to take them.
We'll be around.
We'll be around. We can send them. We're over by a half hour. I thank everybody for coming. This is a wonderful evening. I've had a wonderful opportunity to listen and learn. I thank the present panel. I thank all the panelists tonight.
And I think we all want to thank Paul and Enzo for arranging this.
And although I get up and I want to talk, and it's not me, and I thank you it's Enzo Rondinelli, it's Holly Chapman, it's a lot of people that put a lot of effort in, and it's all the speakers, and it's appreciated. We're on a shoestring budget, and we get fantastic people out. And can't say enough, but thank you. Everyone have a good night.